We'll get started. We have pizza over there since we're starting a little later today. If anybody wants pizza, I'd suggest doing it in advance. We have, unusually for us, a bit of a lighter schedule today. We're going to be focusing on Title 47, the involuntary commitment statute, and the implications of that statute for our topic of chronic inebriates. But I want to start by going around with introductions, and why don't we start with Amanda?
Amanda Moser, Deputy Clerk.
Dick Train Anchorage Assembly.
Elvin J. Johnson.
Pete Peterson, Assembly.
Bill Evans?
Ernie Schlareth, attorney in town.
And even though the tape recorder probably won't pick it up, if you guys in the back will just let us know who's here so we can know what to call you.
Oh, sorry. I'm Brenda Volunteering for Adult Protective Services.
Steve Ashman, Department of Health.
Melinda Freeman, Department of Health and Human Services.
Josh Henseth, Pride Foundation.
Carmen Springer, Anchorage Coalition to End Homelessness.
Stuart Vaden with the Anchorage Community Land Trust.
Christopher Constant, kind of with multiple hats, Gila and Fairview Community Council Business Association.
Joel Catteroach with the Odin Corporation.
Trinidad Chapman, I'm a social work student doing my practicum with LV.
Haley Helvey, I'm a social work intern doing my practicum with the municipality of Anchorage.
Warren Jones, First Covenant Church, APAC.
Janet Jones, First Covenant Church, APAC.
I'm John Spurbeck with Anchorage Community Mental Health Services and also with the Alaska Coalition on Housing.
Great. Thank you all. Like I said, our topic today is Title 47, and our first presenter is an attorney in town, Mr. Schlareth, who's going to share with us his experiences with that statute and enlighten us. So, Mr. Schlareth.
Thank you for the committee to invite me here. I think it's about 20 minutes I have, is that right?
That'd be fine.
Okay. I'm a private attorney in town. I practiced more years than I'd like to admit right here, but quite a few years ago when I was still just starting out, as many attorneys do, they'll ask for court-appointed appointments to represent indigents. And in Title 47, there's a requirement for alcohol commitments that attorneys be appointed for the persons who would be a petition for whom a petition would be brought against. And that's how I got started. Actually, I'll just say it's about 25 years ago when I started that. And over the years, I've done many alcohol commitment proceedings representing the respondent, the person against whom the petition is brought. So today, basically, I come here just to present a picture, as it were, of how things used to be, how the process works in actual fact over the process involved in the actual bringing of a petition and what happens in court. We have the statute, Title 47, and it's all neatly laid out. But as many of you know, when what's in a statute or what's in a piece of legislation, when it goes into practice, there's a lot of different things that happen, as it were, as it goes through the court system. The other thing I'd like to say before I start in going through the statute, just a little bit as an introduction, is that the entire...
Ms. Gray Jackson had a question.
Thank you, Mr. Chairman. And I think you're probably going to do this, but what exactly does Title 47 address? I have no idea.
Okay. So
Thank you, Mr. Chairman.
Title 47 is a statute that's designed to, for public health and safety, to bring help to people that are either suffering from drug addiction or severe alcoholism, severe in both cases. And the statute works on a kind of a gradient. Initially, if a person is found inebriated, drunk in the street, there is actually a way for a police officer to pick the person up and bring him to an approved facility, a facility that's approved by the Department of Health and Social Services. That would be, for example, a place like Clitheroe. And And however, that initial gradient, that initial step is only works for so many hours. I think 48 hours, I think is what the statute is. From there, it steps up a little bit. There's also a procedure whereby there can be an emergency commitment. If a person is found inebriated or heavily induced with drugs, that person and is in danger of harming others, or is totally incapacitated by alcohol or drugs, then there's another procedure involved in this gradient under the statute. An emergency petition or an emergency proceeding, not a petition, but a proceeding can be instituted whereby a family member, a doctor, a guardian, a number of people under the statute can request from the person that is in control, the manager of the facility, to take that individual for a period of time. Under the statute, I think that goes up to 48 hours. But within that, but along with that, before the administrator of an approved facility like Cliff Road will take an individual like that, the statute says there has to be a physician's certificate that authenticates the fact that, according to the opinion of the physician, this person fits the particular provisions of the statute. That is, that the person is in danger of harming others or is incapacitated, totally incapacitated by alcohol or drugs. Then the gradient goes up. Under that proceeding, the administrator of a facility can hold an individual for that number of hours. And if that administrator wishes to hold a person any longer, then the administrator requests from a district court or a superior court judge permission to hold the individual. The individual can be held up to 5 days at that point. If the administrator of the facility at that time also feels like the person is still in need of more long-term services, the administrator of the facility can then request from the district court judge that he be held up to 10 days. But those scenarios don't often happen without being in conjunction with what I'll talk about now under Title 47 is the involuntary commitment proceeding, and that's really the heart of this Title 4737 is the state the state legislature under this statute has devised a method to protect people out in the community who are in danger of harming others because of alcohol or drug abuse or are incapacitated by alcohol. It's a very specific definition. It can't be someone who is simply drunk in the street, as it were, but there must be enough showing, there's a requirement of a physician's certificate, there must be enough showing that the individual involved is in, and to put it in vernacular terms, in really bad shape. And what I mean by that is that a physician's certificate will say often that this is the type of an individual, and this is what you folks have heard and the newspapers have written about in the articles, what I believe municipality may be concerned about are individuals that are constantly needing help from either police, are constantly in the emergency ward of a hospital, are constantly, their condition is so bad that they are, as the terminology is, incapacitated by alcohol. These are severe cases, and there are many on the streets of Anchorage and other municipalities, and so these are people that are often have severe ailments of other types. They may have completely ruined livers, as it were, because of their long-term alcohol substance abuse. And it can be so severe at times, and many times, that a person who is an alcoholic of that magnitude will often seek any type of means of becoming intoxicated. And this could include drinking Lysol underneath the kitchen sink. It could include going to drugstores and buying denatured alcohol. It's quite severe. So, without digressing, what we're talking about is people that are severe alcoholics who are incapacitated by alcohol. That's what the involuntary commitment statute is really designed towards reaching. And so, have I kind of described it?
Mr. Trainee has a
Will
question.
Title 47 also deal with people that are dependent upon when marijuana goes legal? There's people use hash oil. Right now it's running about 38% THC down in Denver. I'm sure it's going to be up here.
Mhm.
Will this cover people that are storing out on?
I think, well, it'll cover drug abuse, and it would cover that. And again, when I preface that by saying we're looking at severe cases, people that are really affected by it. The definition of incapacitated by alcohol or drugs, and that would fit that category, would be, means a person who, as a result of alcohol or drugs, is unconscious or whose judgment is otherwise so impaired that the person, A, is incapable of realizing and making rational decisions with respect to need for treatment, and B, and, not or, but and, B, is unable to take care of the person's basic safety or personal needs, including food, clothing, shelter, and shelter or medical care. And that definition in practice in courts, it is quite a high standard when it actually goes to court, and that and so to prove a case, in order to prove a case for disability or incapacity by drugs or alcohol, one would have to, from my experience over the years from handling the cases, one would really need to bring the doctor in or call the doctor by phone, the physician who did the certificate, and establish that the person is, indications are going into delirium tremens, indications are having hospital emergency visits within 10 times within 20 days or 30 days or something like that. Indications where the police department has picked the person up or intervened with the person 10 times within the last 30 days, something like that. So all those indicators would bring to the mind of the judge that this person really needs help and needs to be placed in treatment.
Thank you, sir.
Mm-hmm. So, and the petition that's brought, I would add that in the process really of bringing a petition for alcohol commitment, you might say that a family member can go down to the probate court and fill out a petition and present it to the clerk down there. But what really is important in the community as a whole is that the stakeholders that are involved in the whole process are all on the same page. And over the last number of years, as everyone probably knows here, there hasn't been any aggressive movement in bringing people to residential treatment through alcohol commitment proceedings. And to start something like that up again would really require the cooperation and understanding, the meeting of all the players, all the stakeholders. And what I mean by that would be the institutions that are authorized, authenticated by the Department of Health and Social Services, what they term as an authorized facility under statute. That would have been Clitheroe, it could be Ernie Turner Center. And those are facilities authorized to take people in on a long-term basis. So how does the procedure work in actual practice? If a family member sees that their loved one is inebriated, is incapacitated by alcohol, is essentially killing him or herself with alcohol, a proceeding like that can be brought. Usually the individual, if he's fallen down drunk in the street, is picked up, goes into an emergency room. Factors come into play. The petition is filed, but there has to be a physician's certificate. The physician might be, it may also be a physician's assistant, incidentally, or a nurse practitioner. That's important to know. So how does that actually happen in practice? If the person is in the hospital, one might get the physician there to actually fill out or fill out the certificate, and that's in this booklet that I provided at that stage. And from there, the administrator of the approved facility would then have the steps would be taken to move that individual from the hospital, if that's where he or she is, over to, let's call it Clitheroe Center. There's interplay there between the administrator and the hospital all of a sudden. The administrator has got to know that that individual is not still in an acute care setting, an acute care need, where he really needs to be in the hospital because it's an emergency case. Well, because the administrator of the facility isn't designed to take acute care patients, so there has to be some working between the parties there. The doctor has to know that this individual, we've got him to a point where he can be placed in that facility. He communicates with the administrator to be able to have him transported. Police officer may be employed through the court system, or state troopers, or perhaps APD might be employed to actually bring the person to the facility. The facility administrator has really got to know to do his job and to make sure his or her job, and to make sure that that he's not taking, or he or she isn't taking someone that really needs to stay in the hospital for a while, that the person is ready for release, that the hospital, the physician might give a week or 2 weeks worth of medications, that so the person could stay in the facility, and once they've stabilized somewhat, then medications can be obtained, the follow-up medications can be obtained through other resources. So there's going to be that working together. There's also some working together with police authorities, because often now the court system will send out an order for state troopers. I really don't know how it would work with APD, frankly, but there's that request. Certainly an officer can attempt to bring, or might bring a person directly over to a place like Clitheroe, and under the statute, as I told you from the beginning, there is that initial gradient where, yes, they can take him in for 24 hours or so, but then the administrator has got to get moving and starts filing the paperwork. And the paperwork, what I mean by the paperwork is the involuntary commitment petition and proceedings. And once that is done, then what happens, the Superior Court judge, usually it's the Superior Court judge, the District Court judge can do it as well, but Superior Court judge is going to sign an order that allows that person to be held up to 10 days. Within that 10 days, there has to be a hearing in court concerning a commitment for that individual for a 30-day period of time. And that person has got to receive notice. They are appointed an attorney, and then a hearing is held before the judge, and the determination is made at that time whether the person is incapacitated by alcohol or in danger of harming others, so that he or she should be held for that 30-day period. Within the 30-day period, now most people who are in that kind of condition, who are that ill with alcohol abuse or drug abuse, will not get better at all in 30 days. All you're really doing is keeping someone off the street and from killing themselves. And so what a good facility will do, like Clitheroe in its day when I worked there, when I worked with them, will do is the counseling that goes on there is they have a captive audience all of a sudden, and they have someone that's is sober now, and they work with that individual at whatever mental level they might be. And their whole goal is to try to get them into real honest-to-goodness counseling. And then from there, they try to talk them into staying longer than 30 days, because 30 days isn't going to do anything for someone that is in that kind of shape. And by golly, more than we realize, more than one might realize, that worked over the years I've done it, that worked many, many times, where the person was convinced to stay 60 days, 90 days, and it actually happened on many, many occasions, because I used to follow the clients that I had, and if the administrator on the 20th day sees that this person is not going to stay the 60 days, when the facility was really running like up to speed, what they would do is file an additional 90-day petition. I think it's a 90. Let's see, 30 days, and then I'm looking at page 10. No, maybe it's anyway. It's an additional. It can go up to 180 days, and at that point in time, if that person objects, that at that point in time, that type of a hearing, the person has a right to a jury trial. You don't have a right to a jury trial in that 30-day hearing, but you do have a right to a jury trial in the 180-day hearing. And most people who are in that position really don't ask for jury trials. The stigma involved in having a six-person jury listen to all your woes, see medical records that are awful, they usually turn that down. So as far as working together, though, the facilities involved have to coordinate with the hospitals. It's very important if something like this were to come up and running again, that the people involved, the players involved, would attempt to go speak with someone in the court system, in the probate court, and say, this is what we're planning on doing again. You're going to see quite a few of these come in now. What kind of procedure do you like us to see? And what you'll probably get from the court is some really good sage advice, some really nuts and bolts, saying, look, when you come in here, please have your ducks in order. Have your evidence, have this, because most of the time, the administrator from the facility, in fact, all of the time, the administrator of the facility isn't going to have a lawyer, and so the administrator is often there presenting, and frankly, the probate master, who usually hears these cases, is doing most of the work. Because the administrator just is maybe sometimes just kind of fumbling and doesn't. But once after so many months and maybe a year or two of doing this over and over again, they get pretty good at it. So I've lost to a few administrators a number of times. So in any event. That would be important for all the stakeholders to get involved in something like this, to make sure that we know what direction we're going in, and it may be difficult to convince and speak with the administrators of facilities because, quite frankly, and what might be understandable, everyone is very concerned about procedures, liabilities. They want to make sure that the institution that they represent is safe and that they can operate safely with what they're doing. That's why it's so extremely valuable to make sure that all along the process we have court involvement, you have court orders. And with court orders, the safety factor is quite good. I really didn't get to it, but and I would have to ask, as far as the audience is concerned, I have to ask for these back. But if anyone has looked through it or had any particular questions, essentially all it is a typical example. I'm starting on page 11. I can go through it very quickly. This would be an example of a proceeding going through court. Starting out with the initial paperwork where the administrator is of the approved facility is given the individual, they have the right to take them. The administrator may say, no, I'm not taking this individual. Under what circumstances would they do that? They would say, I don't think he's incapacitated by alcohol. The hospital or where he's coming from, I don't think he's ready to be discharged. We can't handle someone that's like this, that type of thing. And then the physician's certificate of necessity of involuntary commitment, that's on page 13. That's an absolute necessity. Nothing's going to happen without that. And it could be a physician's assistant, a nurse practitioner. Now, from a practical standpoint, a few years ago, where I got all these drafts from, and I worked with Clitheroe, and then some folks, I think it was from the municipality at that time, that were looking to get this up and running. And I think there was a House bill at that time, House Bill 100 or something like that. But in any event, and they were scratching their heads and looking at the certificate of physician certificate, and they were thinking about, well, the folks that the emergency vehicles that pick people up from the streets, if we had a physician's assistant there through the municipality or a nurse practitioner, voila, maybe we can do it that way. Then we can have someone that will be able to sign something like that and submit it, and it gets submitted to the court along with the application for emergency commitment. The application for emergency commitment is on page 15, and really, what we're doing here is getting the person to the facility or getting the probate court to ask a state trooper or a police enforcement officer to pick the individual up, go to the home where he is or wherever the person is, pick him up and bring him to the facility. This is the initial process. But once you start this, you have to really start the petition for commitment at the same time, because you have a time, you're running a time, running out of time here. You only have so many days to bring these petitions. And so the physician doesn't need to go into any, or physician's assistant really doesn't need to go into any great detail. On page 15, I put down sample answer. They ask, the reason for my belief as to his or her condition is as follows. This physician or physician's assistant would say he is incapacitated by alcohol. A sample answer would be long history of alcohol dependence and overdose of medications, becomes violent to others when intoxicated and at extreme risk of being harmed and cannot make reasonable decisions regarding health and safety. So they're saying something, it has to be strong enough so that the court will sign it and say, yeah, we should bring this in. Because you want to avoid those situations where people are doing this maliciously, where a person really doesn't need that. I mean, we're not talking about simply someone who's intoxicated on the street. It's not necessarily what we're talking about, because that's not necessarily someone who's who's incapacitated by alcohol, yes, they can be brought in. A police officer can take them to Clitheroe, or if it still exists, Clitheroe may not take them, but they can do that.
Mr. Trini had a
Just a
question.
quick question. I see this physical harm on another. What if when they get drunk, they're trying to cause physical harm on themselves? Can this be
Yeah.
used for that too?
Yeah, it's a funny little quirk in the statute that it talks about harm to others, but doctors and in the court process, they always talk about harm to oneself as well.
Okay, that qualifies then.
Yeah, and I think the way it fits is that a person is incapacitated by alcohol. Public, as far as if there's health and safety is concerned, they could be a harm to themselves.
Thank you.
But it
Just
is
looking down there, I just didn't see self, so.
Yeah, that's because it's the way the statute is written. They didn't put self in there for some weird reason.
Mr. Peterson has a question also.
Thank you, Mr. Chairman. I wanted to go back just a couple minutes ago. You said you thought maybe a good idea might be to have a physician's assistant or someone that's a nurse practitioner working with the fire department. Could we possibly change the statute to where it would allow an EMT to fill out the form, or would that have to probably go through the state legislature? Or?
I think that would have to go through the state legislature. Yeah.
Okay.
Yeah. I mean, the state has a big interest in this too, don't they?
They should.
And yeah, I think that was one of the issues when I did this work with some folks a number of years ago on this, and that was a big hang up. How are we going to get a physician's certificate? You know. So and there's a petition for involuntary commitment. You know, the other issue, the other issue too on this, and I think it's something for the municipal attorney's office to really deal with. This is just drafts, and I think from my perspective, when I see these petitions, and if anyone were to ask me, I would say, when you do the petition, just do it as generically as possible, so that you're not going into detail. You don't really want to, with the petition, file medical records and things like that, because then you get into this whole issue of, oh my gosh, you know, you got HIPAA, you have the other federal act dealing with giving information concerning drug and alcohol victims or persons, and so that's why when you see this, it just says it's more generic. For example, in the petition for involuntary commitment on page 17, a sample answer is, has been drinking to excess of 0.300 daily for 30 days, has been suicidal and threatening to others, had 4 emergency room visits, required urgent medical attention, 9 APD responses within the last 20 days. Now there's a person incapacitated by alcohol. I mean, you've shown, you know, and then once it's a court proceeding, once the petition has been filed, then the issues concerning HIPAA and those things, you have those exemptions that come into play. But if someone were to ask me, I would say keep it simple at first. You don't need to go into any great detail. That does the trick. And then the last thing perhaps I would say is that I've done this, you know, honestly, been good 20, 25 years. I haven't done it in years now, but you get to know the people that you bring in or that are brought in and that you represent, and because there's often the administrator is going to bring that 90-day petition, so you go out and visit them again out at Clitheroe, and you're talking to them, and you get to know them, and as an attorney, many attorneys who take this kind of work, they see their client as their client. They have a duty. They feel they have a duty as well to protect their own client, and you get to like the person after a while, and you get to that point. And so, frankly, there are many times you say, look, why don't you go ahead, why aren't you gonna do this 90-day petition, you know? And if they absolutely say, no, I don't want to, well, that's your duty as an attorney to defend them then. But I have seen so many times over the years that I've done this type of work that when they've gone in on a 30-day petition, these people, many of them, stayed. I've had over the years in one situation where a person that went back to his place in the Bush, Alaska, wrote me a letter thanking me for representing him. I've had people that there have been relapses. I've had clients that have gone there, stayed 60, 90 days, and 2 years later they're back again, and things like that happen. But for 2 years, for 2 or 3 years, they were alcohol and drug free. And so the system works. It really works, and it's worth the money. As far as paying for something like this, I think the statute talks in terms of the ability to have the individual who seeks treatment to seek funding from them through the permanent fund, if they that type of thing. And then as far as these agencies that receive state funding for criminal commitments and that sort of thing, I think that there is one could argue that under those circumstances, if an agency is essentially making their income, gaining their income from that population, that by golly, they can throw a few more in there that just come off the streets, and they could work together. They could seek to get that funding from the individual. But I remember many years ago that the agency, state agency that deals with drug and alcohol abuse, the head of that, I spoke with the head of that agency once, and that was his take on this situation. He really went out of his way to talk to these agencies and try to convince them to take these cases on because they're well worth it. So that's it in a nutshell. I was going to go through this, but I think I did. I probably spoke more than my time, but any questions?
Are there any questions for Mr. Schlereth? No? Pete?
Thanks, Mr. Chairman. So are you suggesting that we need to make changes to Title 47? And if you are, what suggestions are you making?
Well, I think that I think that one should go full steam ahead because trying to make changes in statutes takes time. Sometimes it runs across opposition. The statute is there. It can work if there is a desire out there amongst the various stakeholders and players. It can and will work. So I would say go for it. And there are many physicians in hospitals, in emergency rooms that would be more than willing to sign sign a physician's certificate.
Ms. Gray Jackson?
Thank you, Mr. Chairman. Thank you for the presentation, because as I said earlier, I didn't even know that this title existed. But my question is, everybody knows that there's a big-time shortage of beds. So what happens if, you get a lot of commitment and there's no place to put them?
Right, and that's the big problem. Then there won't be a commitment. And what I read once in the paper not too long ago is that there was a commitment here in Anchorage, and they sent the individual to Kodiak, which I am frankly ashamed of, because this is a big municipality. This is the state. The state something should be done to have this facilities up and running here. And then and again, as I say, there's often a lot of pushback because agencies maybe don't want to do it. They're afraid of liability. there just has to be a whole different mind change. But to answer your question, if there's no place to put a person, then the petition's gonna fall apart. It just doesn't work. The person will be let go.
Right. If I can follow up, Mr. Chairman, well, you know, that whole issue with not enough beds is, in essence, part of our mission statement to, you know, to find funding sources so that we can get what we need in this community. And you're right, it is very shameful. Thank you, Mr. Chairman.
Ms. Moser?
I'm not sure if you know the answer to this, but in your experience, what is the most common petitioner that comes in? Is it a family member, or is it the nurse's assistant, or what did you mostly see?
It varies. I think most common may be a family member that's just, you could see the situation. There'll be a parent whose 30-year-old son is on the streets and drinking all kinds of things. They're about ready to die. They're totally frustrated and frightened, and so they'll go to the probate court and, out of desperation, fill something like that out, and the probate clerk will help them. And so I would say a good portion of those family members. There was a while where I was really thankful to see a number of ER physicians, like at Alaska Native Hospital. There was for a year or so, there was one that was quite aggressive. That physician did it on her own, and brought the commitment proceeding. I mean, that took a lot. And then there was some. It could be the person's counselor, but I guess to answer the question, it's often the family member.
Any other questions for Mr. Schlereth? Seeing none. Thank you for your
Thank
presentation.
you. I appreciate
It
you
was very helpful.
asking me.
And I guess we'll move on to our next presenter, Brenda Malatini. And I'll make the other offer while Brenda gets set up. Help yourselves to pizza. I'm about to. We'll have a break for about a minute or two and get back to it.
You guys gotta help us, we can't eat it all. Come on.
He's in another meeting. He said he would be here, but I'm going to text him right now.
We got some time, right?
Yeah. He said that he would try to get here by 11:30, but I'll just let him know.
Okay. Okay, seeing no mad rush to the chow line, we'll get started with our next presenter. Again, regarding Title 47. And Brenda, it's all yours.
My name is Brenda Molatini. I'm the statewide program officer for Adult Protective Services. It's a state of Alaska agency. I was asked to speak a little bit about Title 47 and also about what our agency does. We have 3 offices around the state. One is in Fairbanks, one is in Juneau, and the majority of us are housed here in Anchorage. Last year we received almost 6,500 reports of harm, and those come in from anybody, community members, providers, I'd say the milkmen, but there aren't any of those anymore.
How many did you say? 5,500?
65.
Wow.
Yeah.
In 1 year.
In 1 year. I have 13 investigators for the entire state to investigate those reports of harm. Soon to lose 1 due to budget cuts, so we'll have 12 as of July 1. So as far as Title 47 goes, we don't actually file those petitions, but we are adversely affected by substance abuse. Just over half of all the cases we see are affected in some way, whether it be the caregiver that has those issues or the clients themselves. Ernie spoke of those who were gravely, gravely disabled, and those folks also fall to us. And what we can do is certainly advocate for that person to get treatment, help family members through that process, refer them to other community services. But we're also looking at possible guardianship and or conservatorship for that person to protect them. Because often by the time they get to that place in their life, they've got an alcohol-related dementia, they've got physical ailments, they are not capable of keeping themselves safe or making any kind of rational decisions any longer. And so often that will be the first thing that we'll do, and then we'll work with the appointed guardian in trying to get them some treatment. The program that we offer this state is a voluntary program. All of our authority comes through Title 47. So these are tricky situations for us and often very difficult and time consuming because those people sometimes before they become so gravely disabled have those moments of clarity where they can tell you with some intelligence how they can keep themselves safe and they understand, that this drinking is killing them and this is the way they've done it for 30 years and you're not going to tell me to do any different and no, I don't want treatment and I don't want your services. And at that point, we have to go away. We'll see them come back through the door often and in worse shape than we saw them before. And for us, it's a matter then of really documenting and keeping history for these folks so that we can present that as evidence to the court when we can say, we've got 3 years of this person showing that they've been evicted, they have not met their health care needs, they are living on the street, so on and so forth, so that we can put some protective measures in there for them. And we also can do protective placements, meaning we can put them in assisted living homes should they need physical help or daily reminders for medications, those sorts of things, once they get to the place where they really cannot care for themselves any longer. A few years back, and this frustrates me even still today, there's sort of a philosophy out there that these folks, have the right to kill themselves, they have the right to drink themselves to death. But this is a disease, and it is something that we must address because it affects our entire community. So in 2010, I believe, we got a group together and we began drafting a bill. It was HB 86, which it did a lot of things, but one of the things that it did was it redefined what vulnerable adult meant. And that's when we get involved because there's 2 criteria. They have to be vulnerable and they have to be experiencing some sort of abuse and neglect. So when we expanded that language, we added in there the chronic substance abuse folks so that we could have the authority to address those issues in a bigger and broader way. And that was sponsored by the governor and it was enacted in July of 2012. So we're seeing more of those come through our door as a result of us being able to provide some protections for those folks. But again, it is challenging because they're hard to find sometimes. They certainly don't want to see you. When we show up, it's not a very popular kind of thing, and they're often not linked into any services. They've lost their families have.
Quick question, you say the amount of staff you have is being cut back to 12?
Yes.
Statewide for investigators?
Yes.
So your budget's been reduced. Are you sure? The state gets money every year for alcohol, about $40 million. The state can't dedicate where their funds go. What's your funding based upon? Just the request of the governor's office or the legislature or what? Is there any formula?
I deal with it. I can't tell you that because I don't deal with the budget at all. They just basically say this is what you get.
They tell you being cut back one person next year and good luck.
Yep.
Okay, thank you, ma'am.
Yeah. So, and that will definitely impact us because we're such a small group anyway. But we're going to do our best, the best that we can. We do have something written in our statute that we can use, something called designees. And those are folks that we train and work with in the community. So it can be physician assistants, nurses, tribal entities, folks out in the community, especially in rural areas where we can't get there easily, sometimes not at all for weeks due to weather. We can send a designee that we've trained and have signed contracts with, and they've done all the, the state confidentiality and those sorts of things, to be our eyes for us. And I think we'll end up having to use a lot more of those and develop that program in a much larger way. So last week was really exciting. We trained 12 of the Kenaitze tribe down on the Kenai, who offered up not only to help us with their own folks, but with the community at large down there. So we spent 3 days in training. They're going to provide the opportunity for those folks to come up and shadow our workers so they really see what an investigation looks like. Although they won't be doing the investigation, they will learn to identify those things that are red flags for us when we do go into someone's home, and also be able to identify the risk level to that individual. So we are looking to expand that program in a very large way. So that's about all I have, unless there's questions.
Are there any questions? Strange?
How are you guys gonna be able to adapt to the recreational marijuana that's about to hit the state? Because you're gonna have people, from what I've seen down in Denver, gonna be stranded on that. You're gonna be dealing with them.
Mm-hmm.
Are there any plans to give you any more money to deal with those segments of Alaska society that's gonna be harmed by recreational marijuana?
Not at this time.
Thank you.
You're welcome.
Any other questions? Okay, seeing none. Thank you very much.
You're welcome.
Oh, look at that timing. Wow. Here, actually, Lieutenant, if you want to sit up? Just,
My apologies for my other meeting ran long.
no, this couldn't be more perfect. Our final presenter today is Lieutenant Gillum from the APD's CAPS team. And he is going to give us sort of the Anchorage Police Department's take on Title 47 and related issues. And
yes, well, good afternoon. For those that don't know you, I've been with the Anchorage Police Department for a little over 32 years. Many of your faces I do recognize and appreciate the opportunity to work with you. My purpose today is really about the need for a Title 47. And Brenda, I'm sorry, Mr. Slareth, he had to leave.
Yeah.
I'm so sorry I missed your presentation because I really wanted to hear your part of the Title 47, because I know that there are some issues about how we need to get to where we need to be. And I printed out just something real quick before I left from DHHS, Melinda here, your 2013. I don't have the 2014 numbers. Have you guys printed those yet? Or?
We're still
okay.
waiting for those.
Oh, okay.
You know,
But
they don't look good, let me tell you that.
well, I kind of anticipated that, but primarily you can see that from from 2009 to 13, there's a consistent and maybe a little increasing number of the numbers of individuals that you see in the safety centers. I remember, and I believe the gentleman's name was C.W. Floyd back in 2006, under the Mayor Begich's administration. There was a study done about the cost and the effect of what it was on the city about the chronic inebriates, the numbers of people. And I remember back then, it seemed like there was about 3,000 individuals that were picked up, and roughly half of those individuals were only maybe once or twice a year. And then you started getting down to this critical group of individuals that were picked up either on a monthly or weekly basis. And some of those individuals were picked up either on a daily basis or sometimes on a twice daily basis. We have done, I've worked closely with the CAP team. It's one of the several units that's in my division. I'm a division commander for the Anchorage Police Department under the crime suppression. And what we do is we try to figure out what problems we have in the municipality that affects public safety, and then what can we use to affect in a positive manner that problem. Well, chronic inebriate, we've been involved with it since 2008. And primarily, is there anybody from Fairview here? Fairview Community Council? Or
Chris was.
Chris was, but he left.
Okay.
Back, but he's done.
Sorry I missed that. The Fairview Community Council came to the Anchorage Police Department in 2008 and said, you know, we have critical mass going on here with problems. So the CAP team, they are a small unit within the department. It's a sergeant and 5, 6, and sometimes 7 officers in the unit. There's 5 in there now. So they worked with the council, and they actually come up with 3 major problems within the Fairview area. Chronic inebriates was one, and it really depended on what part of Fairview you were in as to what was the major problem in your area. The citizens identified the chronic inebriates generally around 12th and 13th and Gamble and 12th and Hyder area, although 12th and Hyder also overlapped with drugs and prostitution. If you went a little further east, then it was the prostitution and drug issues. I clearly remember a young woman coming into the meeting and saying, look, I have 2 small children. I can't even let them play in the local park because I have to go out and pick up the needles and the condoms before I allow my child to go out and play in the park. So clearly we had an issue in there in how we worked on this. So the chronic inebriate, you know, it quickly focused around 13th and Gamble and 12th and Gamble because of Cars, Oak and Keg, and the Spirits of Alaska. You might have seen that there's a bit of controversy going on with Spirits of Alaska now. I won't beat that drum to death, but this is something that as long as I've been here, we've had problems with this. We've had a core group of individuals, and obviously those individuals change because unfortunately for this high-risk population, they don't survive too awful long. When they start getting into that small percentile that are picked up, you know, that make up maybe 25% or so of those transports, these are the individuals that we unfortunately see that you know, the life on the street is very miserable for them. I remember when the Carlock Manor was going to become a project, and I know, Melinda, you've heard me talk about this. When I first heard about it, you mean we're going to provide a location for people to live and drink in. You know, the cop in me just says, geez, that just doesn't sound right. You know, I took a wait and see. I wanted to see what the outcome was. And I will tell you, I'm very surprised and pleased to see that there are some success with that. So I don't want to sound heartless when I start talking about this group of people because they are at risk, you know, life circumstances, whether it's their choice or whether it's by circumstance, whatever it is that puts them in this position, they're human beings and we want to do what we can to help them. Well, I think this is the 2nd or 3rd time that I've been before your committee. I remember one young man and one gentleman talking about, you know, sometimes it takes 10 or 12 years to pierce the void for somebody that they finally make a change in their life. Well, during that 10 or 12 years, look at the problem that this individual caused, not just for themselves, but the people that are surrounding them, but also for the community at large, and because of the tax burden and the public safety burden, but also for the neighbors that live in those areas. So the question for the police department is, what do we do with the competing interest here? We have an at-risk population that needs service, needs help, but then you have a community that's supporting through taxes, that are supporting through, you know, charities and doing whatever else, and they are being victimized because they live in this community. So for the police department, we get calls from citizens saying, hey, I need you to come here and take care of this problem. And so we get there, and if there's not a crime or if the person is so intoxicated that they can't take care of themselves, then we do what this Title 47, which I'm certain you heard earlier from. They get picked up and they go into this sleep-off cycle. Sometimes if they're picked up early in the day, the sleep-off will keep their breath check, and when they get to a certain level, then they're back out on the street. The CAP team, when they approach individuals, they're not part of our patrol section, although they look like patrol officers. They're in uniforms, they're in police cars that are marked. They're there to try to figure out how to make an impact. So the CAP team knows these people by name. The CAP team knows their story, and they're trying to help them. A segment of this population is also involved in illegal camping around town. So since 2011, you probably have heard more or less about how the Anchorage Police Department focuses on illegal camps. There was an ACLU lawsuit, so we have to now give them a 2-week notice if they're on public land. If it's private land, it's different, or if it's under state and federal land, the rules are different. But as long as it's a municipality property, then we have to give them 15-day notice to move there. But when the CAP team goes in there, that's not the purpose of the first visit. They're asking them, why are you here? Do you need medical help? Can we encourage you? Can we put you in contact with somebody to get you in better services? Initially in 2011, 2012, 2013, there was some of these individuals that were willing to go into the shelters and to move into this. But there is a core group, and this is the purpose of my meeting here with you today. There is a core group of individuals that do not want you in their life. They will fight you in every which way they can. This is what they want to do. It's unfortunate, and we're talking maybe 2, 3, 4 dozen of these individuals. And this is the core group of individuals that I would like us to focus on how to use Title 47 to get them into, for lack of a better word, involuntary treatment. And I believe that if we focus on this core group of individuals, you start taking 5, 10, or 15 of these, putting them into an involuntary situation, you will impact the overall group, because these people communicate with one another. And I see Mary Beth here, the Catholic Social Security Services. You have Brother Francis and Beacons Cafe. I mean, wonderful services. And I know that there's a lot of people that don't like because of it's concentrated in that area. But if we didn't have them, could you imagine what problems we would have and where these individuals would go? I mean, now instead of at 3rd and Carlick or 4th and Carlick, that problem is going to be citywide. So we recognize that it's a burden for the neighbors in the area. We recognize that there are some issues. I know that what I have proposed, we haven't really gone much further on that, but you have a core group of individuals that are hanging around on the outside of Brother Francis. They're there for the Beans Cafe services. They're not there for the Brother Francis services because A, there's rules there. They don't want those rules, and they're going to do what they're going to do. We need to focus on these individuals because they're adaptive. Some of them are actually manipulative. They're there for a reason. They're going to do what they're going to do. And as long as we, for lack of a better word, enable that. You look at how we have been doing businesses for decades here. We have set up this situation which is have allowed people to, we get 911 calls at the police department, says, I'm drunk, I need a ride, sleep off. And you start looking at the pull on the fire department. I'm surprised we don't have somebody from the fire department talking about how many medic rigs get sent to a man down and it's a drunk problem. I mean, it is a huge drag on public safety resources. So my point is, if we can focus on, and to give an example for the frequency of use, you get down to the intake times between 84 and 270 times a year. There's a core group of about 50 people. And those people make up about 24, almost a quarter of your transports. If you focus on that core group of individuals and you institute a policy or a program that forces people into treatment, you don't have to do all 50 at once. That's too big of a project. But if you could start small with 5, 10, I guarantee you will make an impact with this core group of individuals. I see a question coming.
Mr. Gary Jackson.
Thank you, Mr. Chairman. Thank you,
Yes.
Lieutenant Gilliam, for
Gary,
your
please.
presentation. Gary, thank you so much. But I'm going to ask you the same question that I asked the attorney who gave us an overview on Title 47, which I didn't know existed. I'm glad it's there. But everybody knows that we have a shortage of beds in this community. So how do you, your numbers sound really great and courageous, if you will, but how do you deal with committing somebody and then not having any place to put them?
During the 2008 project, I remember Senator Les Guerra and Representative Johnny Ellis, Mr. Ellis, and I remember Mr. Coffey. I'm not sure if he was on the assembly at the time. There were 2 workshop groups, and when this very question came up. And I do believe the legislature at that time tried to fund about 10 or 12 beds at Clitheroe. The problem was, while they got funding, they could only support a voluntary service, which means people that if they were willing to go into the service, then they would participate. The reason is because if you're going to involuntarily commit somebody to this, you're going to have to secure the area. You're going to have to prevent them from walking away. And that's the problem. They could not be a 24-hour service and be able to prevent them from that. So you're right. It's going to cost money. The question is, are you going to pay the money up front, or are you going to pay the money on the back end of it? Because look at how many millions of dollars is being affected right now. So do we bite the bullet now, do this, and then start making an impact? Because I guarantee you, these individuals that we're talking about, this high-end users, you start putting them into an involuntary treatment center, I guarantee you that you will impact this group, this part right here. Yeah.
Thank you.
Mr. Peterson?
Thanks, Mr. Chairman. And so it's kind of like, the old muffler commercial, you either pay me now or you pay me later.
Yeah, I like that.
And we've been paying through the nose for years.
Yes, you have.
So I feel we have to make some sort of change, because it's the definition of insanity, keep doing the same thing over and over and expect different results. It's not going to happen.
I was trying to figure out how I was going to work Einstein in that, but thank you, sir. So, all right.
Any other questions for Lieutenant? Mr. Trainee?
Thank you,
Yes.
Mr. Chairman. Gary, what about consumable marijuana that's coming?
You,
Because that's going to explode that population group.
You were at the meeting, and
We were
I will
both there.
tell you, I was shocked. I had no idea, because I will tell you that when the initiative came out, I had in my mind, okay, somebody wants to smoke pot in their house, as long as it's not out on the street. I was a little bit indifferent to that. But when I saw what was coming to our community, when I start seeing about the commercialization, when I start seeing what's going to be on the street, the psychological damage, the medical damage, because I wasn't even thinking about the high THC content.
What's the percentage? They told us yesterday, 38, 39%.
Well, that's on the bud. The
Yeah.
concentrates is 90%.
Okay.
What we heard yesterday from an expert in the area was that Denver was it 500 something cases?
Yeah.
People are presenting in the hospitals there because they thought they were on either something synthetic or like LSD or something, and it turns out it's marijuana. One man, they had a homicide there. One man takes one hit and he kills his wife. He is because the impact of the concentrates is going to destroy what we've got here. This is a wonderful community.
Kid that tries it is addicted to it.
That is correct. 1 in 9.
It's not your father's marijuana anymore.
It's not the granddaddy's. It's not even the marijuana you had 2 or 3, 4 years ago.
If you did inhale.
Yeah. Yes.
Sorry, different expression.
Yeah. We are about to go through down path. I hope better minds prevail in the legislature. I hope somebody can wake up and see what's about to happen to our wonderful state.
Nobody else from the chair?
Questions? What would you say is the right size for the CAP team as far as manpower to address this problem effectively?
Well, the CAP team is the primary community policing agent for the department. What we want to do is start moving the department in this type of model. Right now, I've moved the CAP team and our vice and our special assignment unit together to work on a task force that's dealing with the crime, the most recent homicides and stuff, which 9 of those incidents all involved marijuana. The first 2 homicides you saw, those were marijuana rip-offs. If people think that by having commercial marijuana here in this state that it's going to be safe where people can just go and get it and drive home and use it, the black market skyrockets through this. Denver, the hundreds of millions of dollars that they've collected, what was the thing? They said they may have to wind up giving the tax money back.
Back to the growers, yes.
Yes, because of the way it's
Where their tax law was written.
yeah, it's You know, we have no idea about what we've really gotten ourselves into. The good news is there is the ability to try to curb some of it, and if we're really smart, we'll try to figure out how to take the commercial marijuana off the table altogether.
Well, Gary, Gary, they also showed us pictures of Santa Claus with buds in his bag.
Yes. The industry will target your children, absolutely.
Was
Because
it
there's
the
only
Cookie
two
Monster
things.
with the bag?
Yeah, there was I'm sorry, I don't remember the character, but it was one of the common characters. And they target that because there's only two ways for that industry to make money. It's the current user use more and to get new customers. And they are, I mean, it is shameful, the type of advertising that's being done in Denver right now to target children.
I know
It's
I
absolutely
talked to
shameful.
a hotel here in Anchorage that's been approached from outside to have a marijuana package where people can fly up here to Anchorage, stay in one of the hotels, and pick up their product here and go and use it in the wilds of Alaska. This is a major hotel that's looking at setting a package like that up.
I mean, I will tell you that most of the people I talked to thought, well, this is not what we were talking about. This is not what we voted for. You know, we were thinking it was going to be a personal right issue and somebody doing the privacy of their own. No, that we were outspent. There was, what was it, $60 or $100 million from outside interest groups that were focusing because Alaska is supposed to be a great capital venture for the commercial marijuana use here.
Well, the ad said it was north of the green gold future.
Yeah.
The books are encouraging people to come to Alaska and get it on the ground level.
Any other questions, Amanda?
I have a question unrelated to marijuana.
Thank you.
When Ernie spoke earlier, one of the questions that Member Peterson asked was about having, there's a specific list of people who can be involved in the involuntary commitment, and Member Peterson asked about adding EMT to that list. And maybe this might be a better question for the fire department, but do you have are you familiar with what I'm talking about, or do you have any thoughts on that?
Yeah, there's, for lack of better words, you gotta have a dog in a fight, you know,
Yeah.
for this one individual that you wanna do, whether it's a
Family
guardian.
member.
And Brenda, you might be able to help answer some of that, but, you know, who can then apply to the court to put this one person in there? And I don't know the exact phraseology in the statute for that, but yeah, it's going to be hard for public safety to come in and say, well, that guy has been, you know, picked up, you know, 275 times this year. Let's get him. So there will need to be a process, and certainly that individual has rights, and we need to make sure that those are looked at and paid attention to. So, yeah.
I guess, if you don't mind, one thing that I've been thinking about during this presentation is, you know, who sort of knows the frequent flyers or, you know, the repeat offenders, and it doesn't maybe specifically seem to be folks on this list, because it seems like it's the CAP team and EMT and the sleep off center. So it might be interesting if there was a way to have like a working group or a task force or somehow that people are working together to help.
Well, DHHS has the names of the individuals. They run the contract, so they know.
Okay.
That's in their report.
Okay.
Yeah.
So that might be.
Any questions for Lieutenant Gooding?
Oh, you're letting me off easy. So,
Well, we do appreciate you
No,
coming
no,
back
no.
and appreciate you working with this committee on this issue, and I'm sure we'll be in touch as we go forward still.
Still there, sir. I'm just a phone call away. If you need anything, I'm pretty quick to get back here, so.
We
Thank you.
appreciate
All right.
Okay. It's now time in our agenda for member comments. I just want to actually start off by just kind of giving everybody an update of, you know, where this committee is likely to be going in the next several months. I think most of you that are on our email list received the question from Ms. Moser about any other topics you would like to see the committee address, and we received a number of good suggestions on that. and we'll be planning on going through that list and trying to get as many of those slated as possible. I think the goal of the committee is obviously to come up with a plan for action that will include a bunch of the things we've been hearing about over the last several months. I think ideally we should have something in writing that will work, I think, with the timing of everything this summer would be the ideal time. We want to have certainly something tangible before the budget season rolls around next fall. With that in mind, we're probably looking at only maybe 2 or 3 more monthly meetings of this committee. So April and May, and perhaps into June, depending on the topics we have and what we need to do. After that, we'll be kind of focusing on putting everything we've heard together in some kind of usable format. So if there are issues, if you didn't receive the email or you have other issues that you think you would like for this committee to be aware of before we start getting down to the nuts and bolts of coming up with something, please let us know. Please contact Amanda. If she doesn't have your email already, please give it to her and we'll get you on our list. With that, any other comments from the members?
Not right offhand, no.
No, thank you.
Mr. Training? Seeing none, we have plenty of time this time for audience participation, which is a rarity. If there are any issues that you'd like to bring up today on Title 47 or this topic in general, we'll be glad to hear you. Yes, sir.
Well, first, I guess I'd like to introduce myself. My name is Dan Loring, and thank you for what you do on this ad hoc committee. I have not attended any previous meeting. And so the conversation, I'm confident, will result in improvements to neighborhoods in Anchorage. In our neighborhood, which is Fairview, we have a problem liquor store that's been a problem for a long, long time. That's been protested by the community council. It's on the agenda for public testimony on March 24th. And so I would just hope, that this committee and people in the room would see the denial of that liquor license and holding of the conditional use as one concrete step to improve neighborhoods that we could, take, very, very soon. That would not cost money, but again, I just think what you folks in this committee doing is going to be very, very helpful.
Thank you, Mr. Loring, and thank you for testifying on Tuesday on that as well. Any other comments, questions, concerns? Melinda?
I used to work extensively with Mr. Schlereth when we were providing the treatment for people who were involuntarily committed. And with the resources it takes, I think it's very wise that the Assembly members have been addressing the cost of what it takes. When you place someone in treatment under a Title 47 commitment, you have to continue to go back and forth to court. He sort of addressed that briefly in his discussion, but it's an extensive amount of documentation from the treatment providers to then justify the extension of the person being in treatment. And he was spot on when he talked about how often people who are involuntarily committed decide to stay in treatment voluntarily, which then takes the court thumb, if you will, off of that individual who's receiving treatment. So most of the time we worked with the person who was committed to try to encourage them to stay in treatment voluntarily, which worked a great deal of the time. It was really wonderful to hear from Mr. Schlereth from the legal perspective how often and how effective it was. I didn't know from his perspective what his views were related to this. I just thought he would be a valuable speaker coming from the legal arena. One suggestion I would have, if we look at reinvigorating Title 47, is that one of the stumbling blocks, the obstacles, was that you had to use a physician to sign off on the commitment.
In rural areas, we tended to be able to use a nurse practitioner or a physician's assistant. It seemed like we were unable to apply that in an urban area. So Brenda, perhaps you could enlighten us on that difference. But it is extremely challenging to have a physician deny someone their rights by saying, you know, they are so incapacitated. Because we have the statistics. We have them from the safety center. 25% of the people are, as Lieutenant Gilliam said, being picked up sometimes twice a day, and the resources they're using are tremendous. We need, in my opinion, a vehicle to get these people off the streets and have them make better decisions. The Sleep Off Center, although incredibly important, is not the long-term solution to the problem that we've been addressing for years in Anchorage. And so Title 47 is one method. And if we could use a lower level of a medical provider, I can't actually, in all good conscience, recommend an EMT. You're taking someone's rights away, if you will. And so an EMT does not have the training to be able to, I think, choose to do that. They certainly could contribute to the information, but I don't think that they have sufficient training to say, yes, I'm signing off. I don't think they would want that responsibility. I don't think they're paid enough for that. But if we could reduce that requirement to a nurse practitioner or a PA, I think that would help facilitate this. And he's also accurate. We have to reinvigorate Title 47, we have to get back into the judicial system to see how they view this now. The therapeutic courts are one avenue to do it, as well as ASP, ASC, and the medical community. So Brenda, maybe you could help us understand, is it still, can we use PAs or
we have been able to do it successfully, but there were provisions made for the rural areas because the physicians were traveling, so they weren't always there, and so they allowed for those nurse practitioners to sign up on those petitions.
One key change that occurred was when Ms. Malatini addressed that statutory change in 2012 to allow us to serve more effectively, if you will, vulnerable adults, and defining what constitutes a vulnerable adult. We didn't have that when I used to direct Clitheroe, and still we were able to receive these people, and they made fantastic changes. We could only accommodate 3 at a time at Clitheroe because of how intensive it was to do the documentation. And when if they chose to leave treatment, you had to call the police or the airport police to retrieve them and say, do you want to go into jail or come back into treatment? So it's quite labor intensive. Now Clitheroe does not have detox beds at this time. We had detox and residential treatment. So the structure of the treatment system was more robust when we were doing this in early to mid 2000s. So now we have actually a statutory change to help us in the definition of what is a vulnerable adult. So that would help. But we've lost ground on the treatment beds and detox beds.
Thanks, Melinda. Any other comments on that or anything else?
Well, Melinda, was some of the challenge with that the workforce development issues too, in terms of being able to staff the detox facility and having the level of staff by those providers that they needed to be at the capacity level?
It was a twofold problem related to running detox. One was it's a very difficult job, just like working at ASP or ASC. And so it was difficult to recruit and retain nurses when an entity like Salvation Army is competing with the other hospitals that will pay educational reimbursement. It's very hard to compete to recruit nurses. So it was a capacity issue actually in detox to hire enough nurses and to retain them. And I don't know how challenging that might be for Ernie Turner currently, since they are the only detox facility right now. And so as treatment budgets decline, and now they're in another serious decline, even though we could pay for treatment with up to 50% of those alcohol taxes may go to providing treatment revenues. But so it was a capacity issue too. Funding and a recruitment and retention capacity issue.
Okay. Thank you. Any other questions? Seeing none, we are adjourned early, and just check your emails for our next meeting, which will be first Thursday of April.